Adding a child on a bank account can make life a lot easier so they can help with money and bills and just the day-to-day expenses. However, adding a child as a joint owner on your bank account can have drastic legal implications. Hi, I'm Alec Osland, an attorney at the Yanowitz Law Firm, where we've been assisting Minnesota families with wills, trusts, and probate for over 3 decades. Yes, adding a child or someone else as a joint owner on your bank account can make your day-to-day life much easier, as it allows that child to access those funds to pay bills, manage the money, investments, and things like that. However, it can have large legal implications, and there is a better, safer option. So, what are those legal implications that I allege to? Well, in Minnesota, when someone dies and they have an asset with a surviving joint owner, that asset passes automatically to the surviving joint owner. For example, say you have a bank account with $50,000 in it and you have 3 children. Well, if you've named one of those children as a joint owner on that bank account, and that child is helping you out with the expenses and managing that money, and if you have a will or a different type of estate planning document that says, upon my death, all of my assets go equally to my 3 children, when you die, that bank account does not follow the distribution of your estate planning documents. It will go automatically to the child who is the surviving joint owner. What that means is that the other siblings may feel like the child who inherited that account as the joint owner, they essentially got swindled out of part of their inheritance, and their feelings are going to be hurt, and potentially it could fracture the family. So we want to make sure we're keeping the harmony when you die. So it's very important that we don't have children listed as a joint owner on the account, because again, we want to promote that family harmony when you do pass. Further, when someone is named as a joint owner on an account, that means that they are a legal owner and they can use that money however they want. Now, we hope that your child would not steal from you and use those funds in a way that you would not approve of. However, this type of ownership structure also makes your assets available to additional creditors and liabilities. For example, if your child has a creditor who has a judgment against him or her, or if your child goes through bankruptcy, or if your child gets divorced, all of those actions attack your child, and that may mean that the account that they are a joint owner on with your money, it may make that account available to those other third parties as an available asset. Essentially, the biggest takeaway from this video is that you should not name a child as a joint owner on your bank accounts. Well, then what should you do? If you want help with the bills and the day-to-day operations, you should have them listed as an authorized user on the account. This allows them to easily access the funds and help with the day-to-day expenses. However, they have no legal ownership of the account. Otherwise, another option would be to prepare a power of attorney that names that child as your agent. This would allow them to help handle your financial affairs. It is important that you work with an attorney to make sure that power of attorney is prepared and executed correctly, so that there's no issues when that child attempts to help you out using that document. Making sure that your assets are titled correctly is a great way to protect your interests and keep the family harmony, which is why it's vital to make sure your assets and estate planning documents accomplish the goals that you have. If you're interested in learning more about estate planning, make sure to subscribe to get notified when we post a new video. Thanks. Have a great day. Bye.